Our hearing today will focus on a civil rights issue that goes to the heart of America's promise of equal justice under the law, protecting all Americans from the scourge of racial profiling. Racial profiling is not new. At the dawn of our republic, roving bands of white men known as slave patrols subjected African American freedmen and slaves to searches, detentions, and brutal violence. During the Great Depression, many American citizens of Hispanic descent were forcibly deported to Mexico under the so-called Mexican repatriation. And during World War II, tens of thousands of innocent Japanese Americans were rounded up and held confined in internment camps. 12 years ago, in March 2000, this subcommittee held the Senate's first ever hearing on racial profiling. It was convened by then Senator John Ashcroft, who would later be appointed Attorney General by President George W. Bush. In February 2001, in his first joint address to Congress, President George W. Bush said that racial profiling is, quote, wrong, and we will end it in America, end of quote. We take the title of today's hearing from the promise President Bush made that night 11 years ago. In June 2001, our former colleague, Senator Russ Feingold of Wisconsin, my predecessor as chairman of this subcommittee, held the Senate's second and most recent hearing on racial profiling. I was there. There was bipartisan agreement about the need to end racial profiling. Then came 9/11. In the national trauma that followed, civil liberties came face to face with national security. Arab Americans, American Muslims, South Asian Americans faced national origin and religious profiling. To take one example, the Special Registration Program targeted Arab and Muslim visitors, requiring them to promptly register with the INS or face deportation. At the time, I called for the program to be terminated. There were serious doubts if it would help us in any way to combat terrorism. Terrorism experts have since concluded that special registration wasted Homeland Security resources and, in fact, alienated patriotic Arab Americans and American Muslims. More than 80,000 people registered under that program. More than 13,000 were placed in deportation proceedings. Even today, many innocent Arabs and Muslims face deportation because of special registration. So how many terrorists were identified by the Special Registration Program? None. Next Wednesday, the Supreme Court will hear a challenge to Arizona's controversial immigration law. The law is one example of a spate of federal, state, and local measures in recent years that, under the guise of combating illegal immigration, have subjected Hispanic Americans to an increase in racial profiling. Arizona's law requires police officers to check the immigration status of any individual if they have, quote, reasonable suspicion, close quote, that the person is an undocumented immigrant. Well, what is the basis for reasonable suspicion? Arizona's guidance on the law tells police officers to consider factors such as how someone is dressed and their ability to communicate in English. Two former Arizona attorneys general, joined by 42 other state attorneys general, filed an amicus brief in the Arizona case in which they said, quote, application of the law requires racial profiling, close quote. And of course, African Americans continue to face racial profiling on the streets and sidewalks of America. The tragic killing of Trayvon Martin is now in the hands of the criminal justice system. But I note that according to an affidavit filed by investigators last week, the accused defendant, quote, profiled Trayvon Martin and, quote, assumed Martin was a criminal, close quote. The senseless death of this innocent young man has been a wake-up call to America. And so, 11 years after the last Senate hearing on racial profiling, we return to the basic question. What can we do to end racial profiling in America? We can start by reforming the Justice Department's racial profiling guidance, issued in 2003 by Attorney General John Ashcroft. The guidance prohibits the use of profiling by federal law enforcement in, quote, traditional law enforcement activities, end of quote, and that's a step forward. However, this ban does not apply to profiling based on religion and national origin, and it does not apply to national security and border security investigations. In essence, these exceptions are a license to profile American Muslims and Hispanic Americans. As the nonpartisan Congressional Research Service concluded, the guidance, quote, numerous exceptions may invite broad circumvention for individuals of Middle Eastern origin and profiling of Latinos. Today, Congressman John Conyers and I are sending a letter signed by 13 senators and 53 members of the House asking Attorney General Holder to close the loopholes in the Justice Department's racial profiling guidance. Congress should also pass the End Racial Profiling Act, and I welcome the attendance of my colleague and a former member of this committee, Senator Cardin of Maryland, who has taken up this cause from our colleague, Senator Feingold, and he's here today to testify. Let's be clear, and I want to say this and stress it. The overwhelming majority of law enforcement officers perform their jobs admirably, honestly, and courageously. They put their lives on the line to protect us every single day. But the inappropriate actions of a few who engage in racial profiling create mistrust and suspicion that hurt all police officers. We'll hear testimony to what has been done in a positive way to deal with this issue by Superintendent of Police. That's why so many law enforcement leaders strongly oppose racial profiling. Racial profiling undermines the rule of law and strikes at the core of our nation's commitment to equal protection for all. You'll hear from the experts on our panel today. The evidence clearly demonstrates that racial profiling simply does not work. I hope today's hearing can be a step towards ending racial profiling in America at long last.